can initiate the live streaming. Please proceed, Trina.
The Supreme Court of Guam is now in session. The Honorable F. Philip Carbolito, Chief Justice, is presiding.
Will the clerk please call the case?
This is Supreme Court case number CVA19-024 in re High Life Tours, LLC, petitioner appellee versus Government of Guam, Department of Parks and Recreation, William N. Regis in his official capacity as the Director of the Department of Parks and Recreation, respondent appellees. Ocean Jet Inc., applicant for intervention and real party in interest appellant, and Guam Ocean Park Corporation, joint applicant for intervention and real party in interest appellant. Appearing for the plaintiff, appellee, High Life Tours, LLC, is attorney Joshua D. Walsh. Appearing for the respondents' appellees, Governor of Guam, Department of Parks and Recreation, Government of Guam, Department of Parks and Recreation, and William N. Regis is attorney James L. Canto II. Appearing for the real party in interest appellant, Ocean Jet Inc., is attorney Gary W. F. Gumatau. Appearing for the real party in interest appellant, Ocean Park Corporation, is attorney Michael D. Flynn. The panel consists of Chief Justice F. Philip Carbolito, Associate Justice Catherine A. Merriman, and Justice Pro Tem John A. Manglotnya. Attorney Flynn reserves 10 minutes.
Thank you, Madam Clerk. Good afternoon, councils. We will begin, and at this time, I will acknowledge Attorney Michael Flynn. Yeah, you may begin.
Thank you, Mr. Chief Justice. And may it please the court. High Life Tours, LLC, DBA Joe's Jet Ski, or JJS, had no injury in fact and no standing. As such, the trial court had no subject matter jurisdiction. JJS's verified petition alleged that JJS was informed that Department of Parks and Recreation, DPR, intended to issue rump permit number 6 to an entity other than JJS. But the November 9, 2018 DPR memo contradicts JJS's allegation, stating that JJS is next in line for rump permit number 6. Nowhere in any proceeding has DPR offered evidence that DPR intended to issue rump permit number 6 to any other entity than JJS. So other than JJS's bald claim as to DPR's supposed intention, there was no evidence that DPR intended to issue rump permit number 6 to another entity. JJS's attempt to read DPR's mind or future action was simply conjecture. And the supposed injury to JJS was contingent on DPR, in fact, issuing rump permit number 6 to another entity, which DPR never did. In any event, under Guam Administrative Rules and Regulations 10 GAR section 6115C of the rump rules, DPR was mandated to issue rump permit number 6 to Ocean Jet Club, OJC.
Mr. Flynn, if I may just interject at this time, because jurisdiction is a threshold issue, and you open with this threshold issue. Now, you seem to be arguing that the interest that is expressed by JJS needs to exist with absolute certainty, and that however, under the case law, as I understand subject matter jurisdiction and standing, so long as there's some colorable interest and an injury, in fact, in reference to the party that is seeking to litigate in the particular case, is that is all that's necessary, and that standing, all there needs to be is some colorable claim, and not that it exists with absolute certainty. You seem to be changing the standard, or arguing that there be a change in the standard for purposes of determining standing and correspondingly subject matter jurisdiction.
Yes, thank you, Chief Justice. There actually was no colorable claim, and let me explain why, Your Honor. So the problem is that under the rules and regulations, the next to receive that rump permit number 6 was Ocean Jet Club, OJC. So if OJC under the rules was to receive the permit as it had received it over the past 28 years, then there could be no injury to JJS. In addition, there was no DPR rule promulgated under 5 GCA section 9301, Guam's administrative adjudication law, creating a so-called waiting list for JJS. So JJS could never have actually been injured. JJS has cited to...
You argue, Mr. Flynn, strenuously at what is in front of us is a motion to intervene. We're not reaching the merits of the various claims in this case. And as you strenuously argue under your Rule 24 and Rule 19 argument that all is before us is the motion for intervention. Now, also at the same point in my mind, in reference to the issue of jurisdiction and standing, there need not be a determination at the outset as to whether or not, in fact, those interests exist, so long as, in this case, there was a verified petition that was filed by JJS, which may be treated as a declaration or an affidavit making these claims. That's my understanding for purposes of our pleading requirements. That seems to be sufficient.
Yes, I would just point out, Your Honor, that our position is that while the pleadings did indicate that JJS believed that there was an injury, in fact, there wasn't. There couldn't have been because one, the permit was destined to go to Ocean Jet Club, and two, there was no waiting list. So how could JJS ever be injured? So those are the points that I would make, Your Honor.
All right, understand. We'll move on.
So if there was no actual injury and no injury in fact and no standing, then there would be no subject matter. I'm turning, Your Honor, to the issuance of the writ of prohibition, which we posit was an abuse of the court's discretion. Now, JJS could have pursued injunctive relief against DPR, but JJS didn't do that. And under this court's holding in Dep't, the trial court abused its discretion by issuing a writ of prohibition. So the writ should be discharged and the judgment set aside. The trial court additionally created error in not granting intervention. And the motion.
Mr. Flynn,
yes,
so you're requesting the court to grant your motion to intervene, and then that brings you back to the alternative petition for writ. So you're saying that we should do away with the alternative petition and go to an injunctive type of proceeding or some other adequate remedy proceeding? How will that work as far as procedures?
Yes, Your Honor. I think that the court has, of course, the discretion to order many different things, but the court's previous ruling in Duque made clear that the party cannot pursue a writ of prohibition if the avenue of injunctive relief is available. And that was the case here. So the Supreme Court then might simply, looking at all of the different claims that we've put before the court, may treat them in alternate and order as such, I suppose. So turning to the issue of intervention, Your Honors, first of all, the motion for intervention was timely. Ocean Jet Club and Guam Ocean Park, GOP, had protectable interests. JJS's requested writ impaired OJC and GOP's interests, and neither JJS nor DPR adequately represented OJC and GOP's interests. So the test for intervention was met. And in Sablon, this court made clear that the most important consideration in determining timeliness is whether the delay will prejudice the existing parties to the case. In Sablon, the court also made clear that where there is no showing of prejudice, the motion to intervene cannot be found untimely as a matter of law. Neither JJS nor DPR made a showing of prejudice. And the trial court abused its discretion in considering the argument of counsel as evidence of prejudice. The trial court ignored this court's instruction in Limtiaco that all the factors relevant to determining whether intervention is timely are to be construed broadly in favor of intervention. As a protectable interest, OJC possessed rump permit number 6 in its hand. And OJC's permit for rump area number 6 affects OJC's jet ski business and profits. So unlike the proposed interveners in Shin, who only had a right to purchase property if and when Shin successfully acquired the property following litigation, OJC's protectable interest is not a possible, a contingent, or solely economic interest. And similarly, as a protectable interest, GOP possessed in its hand a written contract licensing the use of rump area number 6. GOP's licensed use of rump area number 6 affects GOP's jet ski business and its profits. And GOP's protectable interest is not a possible, contingent, or solely economic interest. So JJS's writ stripping OJC of its rump permit number 6 and stripping GOP of its license to use rump area number 6 impaired the interests of both OJC and GOP.
Mr. Flanagan,
Yes, Your Honor.
when OJC informed the bankruptcy court that it ceased operations, couldn't that be construed to be a surrender of the permit?
Your Honor, some people might construe that as such, but in fact, they held the permit, and there's no requirement under the rules that any permit holder give up their permit if they pursue bankruptcy. So, Your Honor, OJC's position has always been, and unfortunately, Guam Ocean Park ran into that position when they were trying to acquire a permit. OJC's position and Department of Parks and Recreation's position is that OJC still maintained its permit. So neither JJ Yes, sir.
So every June, OJC is required to renew its license, but how would OJC be able to do that when it gave up the Pangilinan lease and when there are no equipment? And I think according to your co-counsel, at the time that the bankruptcy petition was filed, there were no cash assets, or it was less than $10,000. So each year, each June, OJC will have to renew it because of this license agreement with GOP. But how would it submit the supporting documents to get that annual permit?
I'm sorry, I didn't understand. I didn't hear the last portion of your Honor's comments.
How would it be able to satisfy the conditions for an annual permit when there are no, I guess, assets or even a lease agreement in Area 6?
Yes, Your Honor. In fact, there are other rump areas along the beach line which have no beachside access, and JJS is pushing for a access to rump permit number 6, although that area is not directly in front of rump area number 6. But so what I'm trying to say is that a rump permit holder, and there are various rump permit holders who do this, may simply access at the time that they want to access the permit with not having a lease nearby of property. Their lease may be in a totally different area, and they bring down the jet skis to that area where they can access the rump area. So it's not necessary that a lease be in place. As to the operations of the business, there's nothing in the rules, Your Honor, that states that the company has to be operating every day, 24/7, or even every, once a week or every couple of months. In fact, at this point in time in the pandemic, I'm actually looking off to the left here at the ocean area, and there are no jet skis out there. But that was also the case with respect to many of the rump permit areas prior to the pandemic. And so many of those areas are just not used, even though the permit holder holds a permit.
Okay.
So because neither JJS nor DPR adequately represented OJC's and GOP's interests in the writ proceeding, and all the other requirements of intervention were fulfilled, under Limtiaco and Sablon, the trial court erred in not granting the motion for intervention. And the trial court's decision and order denying the motion to intervene should be reversed.
Yeah, Mr. Flynn,
Sure.
you threw me off a little when you raised the alternative writ and the trial court erred in granting. That was not even part of my preparation. I mean, that has nothing to do with this appeal. This appeal is, as I understand it, is whether or not, and the issues that you raise, if that the trial court erred in failing to grant the motion to intervene. And should we agree with you, and this case be remanded, then the merits of the claims can be litigated, and as to whether or not the writ should be vacated. But that's not before our court in reference to the writ. And I just wanted to see if I'm missing something here.
I apologize, Your Honor. I agree with you. We did place that into the brief to show the court that there were problems with, in addition to those that are on appeal, other problems with the actions of the trial court below.
But again, just to be clear, those issues are not before us on appeal. And the only claim on appeal, as I understand it, is on the motion to intervene. If you're if we affirm the trial court and there was no error on the part of the trial court granting the motion to intervene, then we affirm the trial court in that regard, and your clients do not get to litigate the claims and the corresponding alternative writ. However, if we agree with your arguments that the trial court erred in denying the motion to intervene for the various reasons that you're advancing, then our judgment would be to reverse the trial court, allow your clients to intervene, and then the merits of the claim would be correspondingly litigated, which goes then to whether or not the court properly granted the writ of prohibition.
I apologize, Your Honor. I agree.
All right, let's proceed.
Yes, the other abuse that was part of the trial court's actions, Your Honor, concerned its abuse of discretion in not joining Ocean Jet Club and Guam Ocean Park as necessary parties. So GRCP Rule 19A2I provides that an absentee's presence is required for just adjudication when the absentee claims an interest relating to the subject of the action. And a disposition of the action without the absentee may, as a practical matter, impair or impede the person's ability to protect that interest. As a protectable interest, OJC possess rump permit number 6 in its hand. Similarly, as a protectable interest, GOP possessed in its hand a written contract. And that contract licensed, excuse me, Your Honors, that contract licensed the use of rump area number 6. JJS's writ stripping OJC of its rump permit number 6 and stripping GOP of its license to use rump area number 6 impaired the interests of both OJC and GOP. Venue was proper, OJC and GOP were subject to personal jurisdiction, and joinder would not destroy subject matter jurisdiction. As such, pursuant to this court's ruling in Benavente and Agana Beach condo, the trial court abused its discretion in not joining OJC and GOP as necessary parties. Respectfully, the case should be remanded with an order that the trial court join OJC and GOP as necessary parties to JJS's case. And if Your Honors have no additional questions at this point, I will ask to reserve the remainder of our time.
All right. Thank you, Mr. Flynn. Mr. Walsh, you are recognized, and then we'll get back to you, Mr. Flynn.
Thank you, Mr. Chief Justice, and may it please the court. When a party is seeking intervention into a case 109 days after the judgment is issued and 79 days after the appeal clock is run, has been denied intervention, no error has occurred under the law. More, when that proposed intervention is based upon a property interest specifically barred by law, but cobbled together anyways by proposed interveners, 15 days after that operative judgment is issued, the only sound legal conclusion is the one the Superior Court made here, which is to deny that intervention effort. I think it's essential to review the timeline here, and that's where I'd like to go to next, because that is also, I think the timeline is the basis of Judge Sicola's decision on the trial court level below. We see, and this is a GSER 135 in your excerpts, Your Honors, you see this OJC ceased operations memo, I'm calling it. That's from September 28th, 2018. We have counsel from Ocean Jet Club. And remember, Ocean Jet Club is the only party here that could even argue having some predictable interest. I understand Mr. Flynn argued for the Shabuncha outfit, but it is an Ocean Jet Club motion to intervene. Counsel for OJC, an agent from OJC, confirms to the federal court that they have ceased operations. They mentioned they've got one creditor. Some point after that, in the next week, Joe's Jet Ski goes to DPR and gets that memorandum from November 9th, 2018, following the ceasing of operations, to memorialize its place in line. Now, Justice Magnolia, you had asked earlier about the giving up of the lease. You know, we see that at GSER 132 when Shibunsha gives up the lease for the beachfront property. That's GOP, the Japanese outfit. That happens on November 19th, 2018. And while I agree with Mr. Flynn that that's not dispositive in and of itself, because these operators sometimes can bring their jet skis down to the beach, I think, Justice Magnolia, it is indicative of a broader sort of pattern here, a totality of the circumstances that I think this trial court properly used in making its fact finding, that there was no protectable interest here. There was no property interest here. You take the lease being given up, you get the message to Trustee Ching, you get the averments to the federal bankruptcy court. You actually get that followed up, and we determined this, Joe's Jet Ski did, only because of a Sunshine Act lawsuit. You have averments from Shibunsha Council, GOP Council, agreeing that Ocean Jet Club has given up its permit. That perspective, I suppose, only changes when the intervention claim needs to be made post-judgment. But at the time, as these events were live in 2018, Counsel for Ocean Jet Club, Counsel for GOP were both in agreement that there was no continuation of that permit.
But
so,
Mr. Walsh, if I may just interject at this time, doesn't those arguments go to the merits of the claim? I mean, as Mr. Flynn strenuously argues, this is a motion for intervention. Intervention is to be favored, and it's the standard is that the elements are broadly construed. And you know, he points out very clearly that OJC held a permit that on its face was still valid until June of 2019. DPR was mandated by Section 6115C to allow OJT to continue to operate its business. And it has been for the last 28 years. And the time had not yet come to renew the permit. And if you just pointed out, there is no requirement in 10 GCA or GCR that the permit holder be actively engaged every single day, 365 days during this permit time period. So as for purposes of the intervention, isn't that a protectable interest that is being asserted here?
I don't think it is, Mr. Chief Justice, and I'll tell you why. I think the analysis in Limpiaco requires, putting aside timeliness, the protectable interest, the existence of a protectable interest, right? The averments of a protectable interest. There is no protectable interest here, and the protectable interest that was offered to the court post-judgment comes after the judgment. It's that contract agreement, apparently between Guam Ocean Park and Ocean Jet Club, saying, see, this is our protectable interest created after the judgment in the case we seek to intervene into. So while I understand the merits of whether or not, you know, the permit should properly go over or can be issued, I was arguing before the trial court that we shouldn't get into those merits. But in terms of the limited question that we ask in Limpiaco on this protectable interest, is there one shown here? I think the documents in the record make it clear that any protectable interest claim comes after the fact. It only exists because of it's a contract that's heavily redacted that comes after the petition Joe Chesky filed for the writ relief was. So I think I understand the concern of what we need to just focus on the intervention, but the Limpiaco tells us what is a protectable interest as part of the analysis. And I think in this case, we see no protectable interest because of the facts that are there. And just on the point, Mr. Chief Justice, of the permit, I actually do not see in the record a permit. What I see is a permit signed after the fact by Director Ibanez, but that's not the original permit. The record doesn't have a permit in existence from the previous administration. This permit is somehow signed from 2018 a time period before the DPR director is even appointed to his job. So I think even that is useful, not again to the underlying merits of the case, but to the question of whether or not there's a protectable interest here that supports remanding this back for intervention. We think that
yeah, but your argument, Mr. Walsh, is that there was a permit that was initially issued to OJC. OJC abandoned its business, and therefore the permit was automatically revoked under the regulations, or the argument that is being made, and that now DPR is in a position to issue a permit to the next person in line, which you argue is your client. But I don't think that there is any issue that a permit existed with OJC for the last 28 years. At least that's what the record is that is before us. And if you say that DPR no longer recognize that permit, or there is a process in which that permit is to be revoked under 10 GAR 6115C.
That is absolutely true, Mr. Chief Justice, but I don't think the word revoked is the word that my client was operating under. This is, I think, more akin to there's an area that everybody sort of in this jet ski community knows is not being used anymore because the previous user of that permit declared bankruptcy, ceased operations, and gave up its stakes. So it's not that we were advocating that DPR needed to revoke this. It's that DPR, an agency that for 28 years, I think a period of time that would certainly entitle that agency to a level of deference in the way they operate, established a means and mechanism to fill the blanks in when these permits become available. So when averments were made to the federal judiciary, to the trustee, that this is ceased operations, when Guam Ocean Park confirms that, and they themselves, but one of the proposed interveners here says that permit was given up, we want to get into the case, or we would like to get into the spot. I think those together show that there's not an issue of revocation, it's an issue of a blank space. Gov't Guam has got an open place. We've got tourists coming to the island. Parks and Recreation, as they've done for 26 years, keeps a list. Our Joe's Jet Ski is next on the list. And when Joe Jet Ski is getting pushback on whether or not they're going to get this permit, and they hear, Joe's Jet Ski, as the record reflects, hears that some other entity, not Ocean Jet Club, some other entity is coming in to cut the line, the only way to seek some sort of remedy was to proceed to the Superior Court of Guam and seek the writ relief to arrest those proceedings.
Well, if you're going to rest your argument that the bankruptcy petition in some way invalidated the permit or extinguished the permit, number one, as Mr. Flynn argues, there's nothing in the regulations that state that is the effect in reference to a permit that was originally issued to OJC. And number two, as pointed out in the record, the petition for bankruptcy was dismissed, prior to the filing of the writ. And so what I see in terms of the record before us is we have a permit that on its face seems to be valid through June 2019 that has not been revoked by DPR through 6115C, and any arguments that by operation of law, because of transactions that occurred between OJC and GOP, that goes to the merits of the claim as you've recognized, and not at the status of the motion to intervene.
Mr. Chief Justice, I have no case, and I am not trying to advance the idea that the filing of a bankruptcy petition forms a revocation of a permit. What I do want to advance, though, is what has been advanced by the other parties in this case, including Guam Ocean Park, that permit was relinquished. The government of Guam was informed, I don't need this permit anymore. I have declared bankruptcy. That's what we were told by Ocean Jet Club. And then GOP, when trying to come in and apply for it themselves, confirms that has been relinquished. So the agency, when faced with a situation of a relinquished permit, what do we do for the remaining period of that time in a relinquished permit? And I think the agency did what they would be entitled to do, fill that slot. Now, I can't point to a regulation that specifically allows the Department of Parks and Recreation to post bankruptcy after a relinquishment, issue a new permit to the next person in line. But I think the agency acted within its ability. And I think one of the reasons that it could do that is because the alternative situation would be to just have a blank, unused piece of beach where these rump permits get used, where no jet skis could operate. You had a defunct person who sort of said, I no longer can operate, I declare bankruptcy, I relinquish my permit, please take it back. Then we just have an empty space there and no mechanism to allow the agency to provide a new operator to come in and do that. And I would suggest, Mr. Chief Justice, that would not behoove sort of the public policy of the island of Guam of trying to develop our tourism industry and have our tax dollars, especially because these rumps, even though there are several, they're not all created equal. Some of these rumps are useless, these rump permits, because they're too shallow to be used. So these are extremely viable things. So it's not a question of did the agency properly revoke this, Mr. Chief Justice. Our perspective is when the agency was confronted with the reality that this rump permit was surrendered by its previous owner, who then comes in next? Guam Ocean Parks, yes, Mr. Chief Justice.
I was just going to ask, but how was it surrendered? I mean, I didn't see any evidence in the pleadings at this stage in which OJC says DPR, I'm no longer going to use the company no longer is going to use the permit, and therefore there is a no longer a valid existing permit. I didn't see any evidence to that effect.
You're right, Mr. Chief Justice. That's a little bit, though, of the left hand and the right hand here. The left hand, Ocean Jet Club, doesn't actually say it at the Department of Parks and Recs in the record. The right hand, Guam Ocean Park, does. Guam Ocean Park, armed with the information, Mr. Flynn's client, armed with the information that Mr. Gumatata's client has surrendered the permit, confirms that to DPR. So DPR is put on notice by an attorney who today is arguing on behalf of the proposed intervener, Ocean Jet Club, goes to DPR and says they have given up their permit. It is relinquished. That is in the record, Mr. Chief Justice. So the agency is communicated with somebody on the appellant side of the equation here saying we've given up the permit. So all Joe Jetski did was move forward with a writ action to arrest the agency from giving the permit to somebody else. And I do understand that the argument that is being made this morning is there's no injury, perhaps we should have, only until the permit was issued to somebody else, but that is exactly what would have happened. And that is also the opacity with which Joe Jetski was confronted with by an unanswered Sunshine Act request to the previous director that resulted in litigation to try to get this information out, I think is also worth noting here, because my client, Joe Jetski, would not have even understood that Guam Ocean Park had confirmed the relinquishment unless that Sunshine Act was responded to, and that Sunshine Act only got responded to following litigation. So I think, again, that there is a totality here, not to the merits of the underlying nature of the case, but to this question of, is there a protectable property interest that would give rise under Limtiaco to a right to intervention? And it seems, since the court does want to weigh in a little bit more of these permit things, I will stop my argument now to allow the government some opportunity here, unless the court has any other questions for me.
I just have one question on the timeliness issue, because you argue that in reference to the timeliness issue, from the time that the judgment is issued seems to be the critical point. But it seems to me that had OJC been informed that there was this writ being sought, and that Mr. Flynn is arguing the secretive nature in which the writ was filed, that it was really the behavior of the petitioner for the writ that sort of created this this unknowing action that OJC's validity of its permit is now being questioned. And had there been a proper, or had there been an acknowledgement that this is an issue and that we probably wouldn't be here arguing this issue before the court.
So I'll say two things briefly on that, Mr. Chief Justice, to answer the question. First, the Shabunsha GOP application comes in on November 29th, 2018. So I think the timeliness argument actually doesn't run from the writ, from the perspective of the other side. It's what did GOP do since November of 2018 to find out what was going on with its permit? It did nothing. So the timeline is actually longer. And as to the second point, Your Honor, about who to have told, I think that appears in the record.
Mr. Walsh, why does GOP have an obligation to do anything under a permit that it's understanding, since it had a license, and of course I'm not submitting as to the validity of any of these arguments, but just for purposes of this appeal, why does GOP have the obligation to question the validity of the permit that has not been revoked, and for the last 28 years, so long as they follow the process of applying for renewal, paying it within the period of time, which was the end of August, none of that has transpired. Why do they have a duty to question the validity of OJC's permit?
So they wouldn't, Mr. Justice, but my point is that this is two different entities. So when GOP puts in an application in November of 2018 and hears nothing back, and I'm not saying they didn't hear anything back, I just don't see it in the record, but I have not, gotten into that in discovery. But when they hear nothing from 2018 until the intervention effort, I do think that that is a bit of sleeping on your rights, to the extent that GOP says the permit went to somebody else and we should have got it even though we weren't next in line. That's not an argument about OJC, which is, their argument is, when I said relinquished, I didn't actually relinquish it. And just on that second question, Your Honor, about who to tell, I would just ask the court to look at the verified writ of petition at IAER 001. Judge Jetsky avers in the verified petition, and it's a verified petition that is not countered with any evidence in the record, including the proposed pleading from the proposed interveners, which was unverified. But Judge Jetsky avers, I've been trying to find out from the agency who these people are, and I've been told nothing. I think that's important here too. The verified petition is filed to arrest the proceedings of an agency a bit in the blind, because the agency is not giving any information about where that permit's going, who's getting it. So it isn't directed against an individual party. Don't give the permit to party X, or don't give the permit to party Y. It's a writ that says, I seek to prohibit you from giving the writ to anybody other than the next party in line, and that would have been Judge Jetsky.
But Mr. Walsh, what really struck me with the appellant's brief is the word secretive petition that was filed in December. But we had the November 9 letter to, I guess it was addressed to you, that where the Mr. Kramer from DPR says that should the current permit holder relinquish the permit, then JJC will be the next in line. But why would you not give notice regarding your petition and even your declaration, asking the court to act immediately on your petition? Why would you not, do the additional step of, I guess, doing research with bankruptcy also, whether the bankruptcy petition was over, so that you can give notice to Ocean Jet? That's what I don't understand.
So the first issue on that, Justice Mangaloni, is that the November 9th memorandum was not addressed to me. I didn't obtain that. That was something that Judge Jetsky had. So it's a memorandum that exists that the client obtained, that was the basis of the writ petition. The other thing, and I'm not sure that I can actually point to some aspect in the record here, other than the bankruptcy petitions, Ocean Jet Club was not operating. Right? There was no operations. Once the bankruptcy was declared in the ether, all the equipment was sold and there were no operations. There was nothing going on out there. So I do think, Justice Mangaloni, your concern about did you notify the right parties? Or perhaps we should have taken some steps to notify a party. That party had up and left, had vacated. There was no operations from OJC. Any operations that were occurring there would have been operating because somebody else had some jet skis, but it wasn't those individuals. I'll provide the rest of the time to the government. Thank you.
Thank you, Mr. Walsh. Mr. Canto, you're recognized.
Thank you and good afternoon, Mr. Chief Justice and Associate Justices, and may it please the court. In order to, I don't think that the court can ignore necessary focus in terms of the appropriateness of intervention in this case, that aspect regarding the timeliness of the application. I know there's some concern that whether they have a significantly protectable interest and assessing that may get too far into the weeds in the possible underlying merits, but at the very least, the application for intervention by OJC and GOP was quite untimely. All the case law on this issue for a post-judgment motion to intervene states that the application is timely if filed before the time to appeal has lapsed. And that was not the case here. As is known, the application was filed far after the time to appeal has lapsed. Now, whereas OJC and GOP would try to convince this court that what only matters in that analysis is when they became aware that their rights were no longer represented by existing parties. Well, unfortunately, there is a trump on that by the timeliness in terms of when it is actually filed. Because every single case on this issue, including the cases that are cited by this court in addressing that issue, all deal with interveners coming in post-judgment, seeking to intervene so they can file an appeal because that time is still available to them. And that's not what OJC and GOP wish to see happen. They want to start from square one of litigation of the case back down at the trial court level. And that is simply not available to them. The reason being that if the court were to allow intervention after the time to appeal has elapsed, just based on the appellant's argument that, well, they just weren't aware at the time until much later, well, then there is no finality of judgment available. There's a slippery slope created where years after, someone can undo a judgment and say, oh, I just had no idea, and therefore I should be allowed to intervene because it's only when I became aware that matters. But this court has been clear that even in cases addressing interventions, such as Lim Tiaco versus Guam Music, or versus Camacho, Guam Music Incorporated in parentheses, that parties must be diligent in protecting their interests. And so it is necessary for would-be interveners to be able to assess and protect their interests and know whether or not there is a necessity to intervene in a case without even having been served with a complaint. And that's why we have creatures in the law such as adverse possession of real property, that you have a duty as any legal property owner, whether it's a license or actual ownership of property, to protect your interests. And therefore, because the time at which that application was made past the time for appeal, it is untimely. And that ends the analysis there without even getting into the significant protectable interest.
Well, the problem that I have with that, Mr. Canto, I mean, the cases in reference to Lim Tiaco and Sablan, we had the parties within the case litigating and having a common interest, as we had in Cho. And then at some point in the litigation, the interests diverged. And then it was incumbent upon the party whose interest no longer was being protected to intervene. In this particular case, through probably, well, I don't know whose fault it is, but OJC and OJC in particular did not have any indication of this writ. It was proceeding along with a third party. They were trying to enter into a transaction, and what it thought it had a continuing interest in its permit. And DPW had not indicate otherwise at all, as far as the record indicates in my mind, that permit is not valid. And only until there was knowledge that this permit was no longer recognized by by OJC, I'm sorry, by DPR, did OJC have notice that its permit was no longer valid. And so I went back and read the cases, and I see the language that you are stating, but there are other sections in the opinion that said it's the totality of the circumstances. It's when the parties first become aware that their interests that they're seeking to protect is at risk. And that seems to suggest that there's not a hard and fast rule that the time to appeal is the absolute drop dead date in which a party has to intervene. And so I just don't see that rule in the cases that you're citing to.
I understand, Your Honor. And in that regard, then, looking at the totality of the circumstances, it's necessary to look towards the significantly protectable interest. In that regard, and which paints the fuller picture here for Your Honor, is that OJC did abandon its license because it was not diligent in protecting its interests. It should have, at the very least, said, well, even though we're not conducting any operations in this area for several months continuously, DPR don't think that we somehow gave up on the area, because licenses are revocable by the holder. And OJC has not complained that there's been some violation of procedural due process, that they had some entitlement that warranted them further protection, but they didn't do that. They didn't let them know. They abandoned their license. And in that regard also, so in that context, it should be seen that they're not at the table and therefore don't need to be contacted for purposes of litigation. And they did this in a couple different ways, not just by the non-use, but as the case law requires, there has to be further acts. And that includes the verbal expression of intent to abandon or conduct inconsistent with continued use. And that is the agreement they entered into with GOP, granting an irrevocable and exclusive license to GOP to use its license in perpetuity. So they are stating there that they are abandoning their license. And they also use it in a way that is inconsistent with the purposes of the license, which is another form of evidence of abandonment. That being they used it as a means of barter, as some type of negotiation.
Aren't these arguments for purposes of the merit as to whether or not the license was is valid and under the statute and the regulations, and it's not a transfer of property, but for purposes of the motion for intervention, when there is a OJC has a permit through the end of June 2019, it's not been revoked by DPR for the last 28 years, so long as it filed its renewal and paid by the end of August of the following month, that the practice has been, and what the regulations state, is that they have then a right to the renewal of, at least the argument, of their license. Now, the arguments that you are raising in reference to the effect of certain actions entering into this agreement, writing this letter, that would suggest to me that those are arguments for the merits as to whether or not OJC's actions are valid under the statute and the regulations that apply in reference to its license, to its permit.
Well, Your Honor, the court has to get into this inquiry at some level to determine whether or not there was a significantly protectable interest. And all these arguments that I'm raising are regarding facts that are not in dispute either. So we can call it a lack of standing or something else, but we have to look at it to some degree.
It is in dispute, because as Mr. Flynn points out, my client is maintaining, OJC in this particular case, that it has a permit that was issued in 2018 that expires in June of 2019 that has never been revoked. And even the letter that was sent to DPR in the conditional language that in the event that the existing permit holder gives up the permit, then you are the next in line, which seems to suggest on the part of DPR that that permit still exists.
Understood, Your Honor. And in that regard, OJC has not provided any proof that they complied with 6115G2 by actually applying to renew for that that license before August 31st of the year prior to when they have a certificate signed by a director who was not even the director at the time that they were supposed to have renewed. And 6115G2 says that failure to pay that fee and renew before August 31st shall void a renewal of applicant's permit. And that's a good point. Again, that is another fact that may be a matter of dispute, but in terms of what, I think there's enough before the court in the record to determine, and it's necessary for the court to determine, whether they're allowed to be an intervener. And there is a certain level of showing that must be made as to whether there is a significantly protectable interest, which they have failed to provide, Your Honor.
I'll have Mr. Flynn have the last word on that, but please proceed.
Mr. Canto, what is the procedure now for permit holders with respect to abandonment or revocation? What is it under? Is it at 6115C still?
Your Honor, I have no reason to think that it's any different from what is reflected in the regulations, such as by 6115C. That's correct. And so again, I think though, at the very least, GOP's ability to intervene as a separate party is even more attenuated than OJC's. And I understand a lot of the discussion by the courts thus far has surrounded OJC's standing as a proper intervener. But as to GOP, of course, I think it should be understood that their lack of a significantly protectable interest prevents them from being an intervener. That being because the interest that they claim is prohibited. And I think this is an important point to raise, that they're arguing, OJC and GOP are arguing that it's just a license, we're not transferring anything, whereas 6115C prevents or prohibits any transfer. But they say, well, this is not a property interest that we're transferring, we're simply allowing for the use of our license. But that is a transfer by any other name according to this regulation that prohibits it, because there is no property interest that they could transfer anyway, because it's government property. It's only the permission to use, and that's what they're seeking to transplant, however they want to characterize it, to GOP. And that's why they do not have a significantly protectable interest, besides the fact that it's contingent and purely economic, as the Shin case would illustrate. But the permit itself, though, as a creature, is revocable by the agency. And so whether there's a permit or not, the agency does have the ability to take that permit back and make sure that the area does not stand fallow and is not used when there are other companies waiting in line for that same space. So
I don't think anyone disputes that, Mr. Canto, but the regulation 6115 L provides that before the DPR can do that, there has to be a hearing pursuant to the Administrative Adjudication Act if there is a validly existing permit.
Yes, Your Honor. And I only argue that point insofar as the significantly protectable interest does not exist for OJC to the extent that they would seek to argue. Now, especially given the context, it's two sides of the same coin. Their acts affirmative and by way of omission in abandoning the license arguably does not require a formal procedure for revocation. And that's why I would argue that the agency is in the position to do that, even though they did not take formal steps, because it was largely unnecessary.
But how can you say that when there is a permit that was issued by DPR that, as you argue, has not been revoked? It's not necessary to go through this former procedure, but at least on DPR's books still exists because it was a 1-year permit that didn't expire until June 30th, 2019. And there, as you've mentioned, there's no steps that have been taken or is needed to revoke it. And the complementary statutory provisions that so long as there is a application for renewal within the period of time which had not expired at the time that this writ was issued, and the time period to pay for the renewal, August of 2019, had not expired when the writ was issued, that OJC would, in its mind, maintain that it still had a valid permit.
Your Honor, the writ was issued before that permit could have possibly been issued. There's no date on the permit, and it's highly suspect. But the actual writ by Joe's Jet Ski was filed in court December 27, 2019. The purported permit is signed by a director who could not have come into office until January 1st the following year. So
well, then what I meant is that the issuance then of the permit to Mr. Walsh's client, Joe Jet Skis, that was issued prior to the permit expiring. Wasn't that the case?
prior to OJC's permit expiring?
Yes.
Yes, Your Honor. Yes, that is correct. That is correct. And as I see, I have expended my time. I will rest and thank the court very much.
Mr. Canto, how did DPR arrive at the conclusion that Ocean Jet abandoned its permit or its Area 6?
Your Honor, technically, I'm not aware. I don't have any record that memorializes that thought process that occurred by DPR. I can only make presumptions that are on the same facts before the court that the parties have tendered in terms of why they abandoned it. But as to what constituted DPR's position or decision, I do not know.
Justice Merriman, do you have anything you'd like to ask before Mr. Canto rests?
No, thank you.
All right.
Thank you.
Okay, Mr. Flynn, you may use your remaining time, which is, as soon as it's flashed up, 9 minutes and 3 seconds.
Thank you, Your Honor, and I don't believe that I will use up that full time. Nonetheless, there are a few short remarks that I would like to make. One, just to emphasize, because this, I think, went back and forth between Mr. Canto and Your Honor, the fact that the permit cannot be taken away, Ocean Jet Club's permit, except through a administrative adjudication law hearing, and that never happened. The other point I'd like to make, Your Honor, and it goes to the issue of the inability to present evidence at the motion hearing. And that is, it concerns a number of different issues and facts, Your Honors, but with respect to the permits, Mr. Ibanez, who was the director of Department of Parks and Recreation, was present at the hearing. And in addition to putting him forth as a possible witness for Guam Ocean Park and Ocean Jet, and in support or to elucidate issues, factual issues for purposes of that motion. Guam Ocean Park and Guam and Ocean Jet Club also had a separate witness, and neither of those witnesses were allowed to testify. But one of the issues, the factual issues, is how the permits are issued. And in fact, it's the case we understood with DPR that sometimes they don't have the necessary paper to issue to print out the permit. So those may come out tardily just for that reason. Or it may be the case that the money's paid, the application has been made, and someone who has 28 years worth of permit history behind them is of course going to get the permit again. So those are some of the issues that weren't brought out in the record, but need to be addressed perhaps at the lower court. Your Honor, I won't address the abandonment or relinquishment argument made by Mr. Canto and Mr. Walsh, because I think our briefs fully address that and make clear that there was no abandonment and no relinquishment of that. Another issue that would have come out, Your Honor, in the lower court had witnessed to testify was that Ocean Jet Club went to
Mr. Flynn, we're starting to lose you. Let's just maybe can you try again? Your audio was drowning out.
Thank you, Your Honor. I apologize.
It's fine now.
Another issue that would have been addressed was testimony. Ocean Jet Club went to the court and demanded that they not allow the permit to go to the vessel. So they had no intention of abandoning their permit, and they made that quite clear to the director. Mr. Bilray just agreed that they would continue to keep their permit. So those are all the issues, Your Honor, that I have, and I think that in addition to the arguments I've made shortly, we would also submit the briefs, of course, open brief. If Your Honors have no additional questions to pose, we will submit.
Any other questions?
Yes. Mr. Flynn, in Judge Sokola's decision, she addressed the merits of the motion to set aside the judgment. Do you feel that was fully briefed and presented to the court? Or was that just a reaction from her decision not to allow intervention?
I'm sorry, I couldn't hear the last part of the.
Or was that as a result of her decision not to allow the intervention? I'm trying to decide if her decision is based, so to speak, on the merits or because of the motion to intervene.
Yes, I haven't considered that issue, Your Honor, but it seemed that the trial court, only briefly addressed that issue, Your Honor, and I will, frankly state that as parties, Guam Ocean Park and Ocean Jet Club didn't address that issue in full in their briefing either. So perhaps the trial court didn't feel it had enough information to make a more elaborate ruling concerning that issue, Your Honor.
Thank you.
Any other questions? All right, there being none, Mr. Flynn, thank you for your presentation, and counsels. Thank you for your arguments today. The court will take the case under advisement, and thank you for your presence this afternoon and accommodating the court to moving the hearing to the afternoon. And so at this time, the court stands adjourned.